Welcome everyone during the second meeting of our webinar series, and I pass the voice to Professor Adam Bodnar.
Ladies and gentlemen, it is my pleasure to welcome you at the webinar organized by the SWPS University Riga Graduate School of Law and the Academy of European Human Rights Protection of the University of Cologne. It is the second webinar in the series Road to Reykjavik. We are discussing challenges that concern upcoming summit of the heads of states of the Council of Europe that is going to take place on the 16th and 17th May 2023 in Reykjavik, Iceland. The first webinar was devoted to the future of the European Court of Human Rights. We had a pleasure to host Professor Angelika Nussberger as a keynote speaker. Today we are going to talk about the mechanisms of accountability, especially criminal accountability for war crimes committed in Ukraine, with the presence of the keynote speaker, Professor Filip Sanz. I would like to pass the floor to co-organizers, to representatives of the co-organizing institutions. We have with us Eva Raczynaya and Adam Czarnota from the Riga Graduate School of Law. So, floor is yours.
Thank you, Adam. Good afternoon. It is afternoon in Riga already. Good afternoon from Riga, and a warm welcome to everyone who has joined and who is joining at the moment for the second webinar in this series. And I will be very quick. I just would like to thank our friends already, long-term friends, Adam and Philip from SWPS University, and also Professor Nussberger. And a special thanks goes to Professor Sanz, and of course the discussants and participants, Dr. Reinfischer and our own Christoph Stamusch. And otherwise, a warm welcome. Please join in, think on questions, and have a nice discussions. Thank you.
Thank you very much, Professor Czarnota, Rector of the Riga Graduate School of Law. Would like to add something?
I just want to repeat only that welcome everybody to this webinar, and thanks, Professor Filip Sanz, for agreeing to be with us. Thank you and welcome.
And now I would like to ask Professor Angelika Nussberger, former Vice President of the European Court of Human Rights and the head of the Academy at the University of Cologne. Angelika.
Yeah, thank you so much, Adam. Thank you to all of you. I'm happy to join in greeting you. And just to say, I think we are a wonderful triangle, Riga, Warsaw, Cologne. We are the most western part of this triangle. And we are more than happy to have Filip Sanz today joining us from the island above us and sharing his thoughts on such an important topic as war crimes in Ukraine and what we can do, what has to be done. So thank you all for joining and for having this teamwork. Thank you.
Thank you very much. Ladies and gentlemen, it would take me at least 30 minutes, if not more, to introduce Professor Filip Sanz correctly. So I think that we have a pleasure to host one of the most distinguished and recognizable international law scholars, a person who has devoted all his life to study international law and especially criminal responsibility for violation of laws, especially committing war crimes, crimes against humanity, genocide, or the crime of aggression. Professor Sanz has been nominated as Queen's Counsel. He's a doctor honoris causa at the University of London. On a daily basis, he's associated with the University College London. But he's participating in a number of trials before all different international and supranational courts. But I think that one should add that he's also author of best-selling books and I think this book, which I have with me, East West Street, which is very special to Polish people because it describes the life and work of Ralph Levkin and Hersch Lauterpacht is one of those most important books in his scholar and writer's career. Professor Filip Sanz is with us because he has proposed as the first one that we need to establish a special tribunal for the crime of aggression concerning war crimes in Ukraine. But it is not the only his only involvement in the discussion on the topic. And I think that because this Council of Europe summit is coming, this idea what to do with the accountability for war crimes should be one of the important parts of the possible Reykjavik declaration. So, Professor Sands, you have observed the process and the discussion on this issue for already a year. So we'll be more than grateful for listening to your comments and for your view on what Reykjavik should do with this particular and very special issue. Professor Sands, floor is yours.
Professor Bodnar, thank you so much and for the invitation. And thank you so much also for reminding us all of the extraordinary contribution that Polish scholars and practitioners have made to this area of international criminal law. It is, I think, almost a unique contribution in the world, along with that great city, which I think is partly, or has been partly Polish, of Lviv, Lemberg, Leopolis, call it what Lviv, call it what you want. I think I'll, given the time available, I'll speak for about 25 minutes, focus mainly, but not completely exclusively, on the crime of aggression, and just say a little bit about how this issue has come up and how it interacts with the other crimes. As you know, as everyone knows, since 1945, we've basically had 4 international crimes: war crimes, well established in the 19th century, 2 new inventions from 1945, crimes against humanity, pushed by Herr Lauterpacht, genocide, invented as a concept by another Polish scholar and practitioner, Raphael Lemkin, and of course, what was in 1945 called crimes against peace, the crime today of aggression. And when the war, because it is a war, began in February 2022, within a day and a half, a British newspaper, the Financial Times, got in touch and asked me to write 700 words on any aspect of Ukraine and international law. They had contacted me, it was pretty clear, because I'd written this book, East-West Street, that is very largely situated in an area that was once the Austro-Hungarian Empire, was once Poland, is today Ukraine, in which the crimes that I've mentioned originated in part. And I think that was what they wanted me to focus on. I looked at the lay of the land and could see pretty quickly, we didn't know then quite how terrible this war was going to be in terms of war crimes and crimes against humanity. There are, of course, also allegations of genocide. On the basis of what I've seen, I think it would be very hard to sustain a genocide case, but of course I don't know what's going on precisely on the ground, so I'm not expressing any view on that. And those 3 crimes, certainly war crimes and crimes against humanity, were of course covered by national jurisdiction in particular, but not only Ukraine, and also because of Ukraine's declaration to the International Criminal Court in 2014, 2015. And of course, Ukraine is not a party to the statute, which raises issues of its own. Nevertheless, the International Criminal Court would have jurisdiction in relation to war crimes, crimes against humanity, possibly also genocide, if there are allegations of genocide taking place on the territory of Ukraine, as it was in 2014. That would, of course, include, in my view, Crimea. But there was a gap. The International Criminal Court could not exercise jurisdiction over the crime of aggression, in part because that was not within the jurisdiction of the ICC in 2014-15 when Ukraine extended its declaration, but also because when it did become part of the jurisdiction of the ICC, it did so in rather limited terms in relation to the involvement of third countries that were not parties to the statute of the International Criminal Court. Russia is not a party to the statute of the International Criminal Court. No one disputes that the ICC cannot exercise jurisdiction over the crime of aggression. And yet, of all the crimes, and we've seen some terrible images on our screens and read about them in our newspapers, it seems to me that the crime of aggression is the starting point for any assessment of what has happened since February 2022. Without the decision to go to war, none of the other crimes would have been committed. I exclude here, of course, parts of Donbass and Luhansk and Crimea. But the bottom line is that is the central crime. And it is also the only one which is only a leadership crime. And that issue was very much in my mind already in February 2022. Why? Because I already then had a concern that we might find ourselves in a situation several years down the line in which a group of perhaps very low-grade Russian soldiers might find themselves hauled before the International Criminal Court being prosecuted for war crimes and crimes against humanity, whilst the people at the top table would get off scot-free. In other words, to not put the accent on the crime of aggression firmly is essentially to open the real possibility that those who are most responsible for those horrors will somehow avoid legal scrutiny. It's very difficult to prove, as prosecutors will tell you, by way of command responsibility, the involvement of the people on the top table, Mr. Putin, Mr. Lavrov, Mr. Shoigu, and others, for what happens on the ground in Bucha, in Irpin, in Mariupol. It can be done, but we know from the work of the ICTY, the ICTR, and the ICC, this is immensely time-consuming. It's fraught with difficulty. It's uncertain. It's not impossible, but it's difficult. Why put yourself through all of that when you have a crime out there which deals straight with that issue? And that is the crime of aggression. It's the only one that goes straight to the top table. And that's really was the purpose of my article, to put that on the table. Now, many people on this call write op-ed pieces in newspapers, and like me, you will have had the experience of writing something and the next day, 11 people and their dogs get in touch and say, congratulations, wonderful. And then nothing happens and you move on to the next thing in life. And that's fine. That's really how, life is and life should be. And I fully expected that to happen after I published the article in the FT on the 27th of February, but that's not what happened. What happened the next day was a deluge of communications by all means possible. Email, Twitter, text messages, WhatsApp messages. It was absolutely overwhelming, and media requests from all over the world. It really surprised me. It was as though this issue had touched a nerve and generated a lot of interest. Amongst those who were interested were some pretty significant people, 2 British former prime ministers, for example, and former leaders of many other countries. The main person in that score was a former Prime Minister, Gordon Brown. This, of course, was not without its difficulties, because Mr. Brown was the number 2 back in 2003, when the United Kingdom went to war in Iraq with the United States. My own view has been clear and consistent since 2003. The war in Iraq was manifestly illegal, and it also gives rise to considerations of the crime of aggression. Indeed, that was what the Deputy Legal Advisor at the Foreign Office, Elizabeth Wilmshurst, famously wrote in her resignation letter at the end of March 2003. So there was a moment of pause when Mr. Brown asked, I didn't know him previously, whether he could join forces with me. And indeed, I have had from many people some difficulties in relation to the association with that individual. But in relation to Ukraine, my sense was we are where we are, and perhaps one could understand it as a form of mea culpa that he wished now to associate himself with an initiative on the crime of aggression. Now, the person who got in touch was the Foreign Minister's office, the Foreign Minister himself, actually, of Ukraine, Mr. Kuleba, who is an international lawyer and had written a paper in his student days on the famous Declaration of St. James of 1942, which was attended by a number of governments in exile in London, including the Polish government in exile, and which issued a rallying call in the Declaration of St. James for the prosecution of senior Nazi criminals after the war was over. And of course, it was that Declaration of St. James which prompted Roosevelt and Churchill and Stalin later to get involved, the creation of the UN War Crimes Commission, and so on and so forth. Another way of getting to these issues is I've come to understand in my own work, watching in particular the activities of individuals like Lemkin and Lauterpacht, that individuals can make a difference, that ideas can make a difference, that articles can make a difference. And I'd seen that taken forward, of course, in many other areas in which I've been involved. The upshot was, within a week, Chatham House, the Foreign Policy Institute in the UK, held a meeting. It was, I think, I was told, the largest meeting ever attended at Chatham House, more than 1,500 people on Zoom on the crime of aggression. It was huge. And the next thing that happened was that Mr. Brown opened his address book at the request of Dmytro Kuleba, the foreign minister of Ukraine, who expressed the support of Ukraine for taking forward the idea of the creation of a special criminal tribunal for the crime of aggression. Mr. Brown introduced a small group of scholars to former leaders, heads of government, heads of state, mostly from Central and Eastern European countries, the Baltic countries, the Czech Republic, Bulgaria, Georgia, and so on and so forth. I don't think there was anyone from Poland on in the very first calls to discuss the options, and it sort of snowballed and spread. And by the summer of 2022, there were about half a dozen countries who were firmly behind this idea in support of Ukraine's idea. Poland was amongst them, the Czech Republic was amongst them, led by the Baltics. And then the Netherlands came on board and said, yes, we're willing to offer a space and be supportive, but we want one of the bigger powers to come on board because that will give it credibility. The bigger powers they meant, of course, was in the European context and Western European and others group context, France, Britain, Germany, the United States. And at that point, in the summer of 2022, they were resolutely opposed. By now already, we were beginning to tease out some of the legal issues that arose. There is, of course, the very significant question of immunity and whether, under international law, it is possible for a serving head of state or foreign minister or defense minister to be able to claim immunity in relation to the crime of aggression. And the debate on that issue focuses very largely, there are different views, on whether you're dealing with an international court or a national court. And this becomes very central in the point we are at now. So I'm putting a marker down for those who are listening to be aware of that very significant difference. There is some authority, significant authority, but not complete authority, the proposition that if you've got an international court exercising jurisdiction, the entitlement to claim immunity, even for a serving head of state, may be more difficult. For a former head of state, I think it's not a problem at all. But for a national court, it's frankly pretty problematic. So this issue of national or international, or again, to come up with another form of words, an internationalized or a hybrid court has dominated the discussions. The first of the big countries to crack was France. You may not be aware, but France has been, ever since Nuremberg and the invention of the crimes against peace and the crime of aggression, resolutely opposed to this crime. And that's the Quai d'Orsay rather than individual politicians. But I think we can fairly understand that it was the French foreign minister, Catherine Colonna, who was not personally so opposed to this idea. And I noticed by September, when she made a trip to Kiev, that she was leaving the door slightly open. And indeed, a few weeks later, France did announce that it could recognize the possibility of the creation of some sort of special criminal tribunal for the crime of aggression. I just want to put another marker down on an aspect of this that is significant and I think potentially very important for what is coming. The crime of aggression under the nomenclature Crimes Against Peace was included in Nuremberg in 1945. Ironically, and I cite here to the wonderful book and work by Francine Hirsch from the University of Wisconsin, who has looked at the Soviet role at Nuremberg, the crime was introduced into Nuremberg over the opposition of the British, French, and Americans by the Soviets, ironically enough. and by a single jurist called Aaron Trainin. It made its way into the Nuremberg Statute, and immediately after the judgment of Nuremberg in the autumn of 1946, rather amazingly, 3 countries introduced into their penal codes the crime of aggression, and they were the Belarus Soviet Socialist Republic, the Ukrainian Soviet Socialist Republic, and the Soviet Union itself. And they have remained in their penal codes ever since. So we're in this sort of remarkable situation in which the crime of aggression is actually integrated into the domestic laws of the three of the most relevant countries in relation to this conflict. I've always thought that is important because that provides basis for going forward. Anyway, back to the autumn of 2022, France cracks first. We had always known that Germany would essentially do what France did. Because of their axis, they would not want to separate. Germany was skeptical. The Greens and actually the CDU were very in favor of doing something, but it was the Social Democrats who were extremely opposed, and I think they're still extremely anxious. As you know, we've got a coalition government in Germany, and so views are somewhat divided. But they came on board, as did the British. In the case of the British, there is one very strong proponent, and that is the Attorney General of Britain, Victoria Prentice. And here there is an interesting point of connection. Like me, she was taught by Hersch Lauterpacht's son at Cambridge University, Ellie Lauterpacht, who some of you will know. And even more remarkably, by complete coincidence, when Ellie Lauterpacht retired and ended up selling his house in the north of the United Kingdom, Victoria Prentice lived in it. So she has a real attachment to the life and work of Hersch Lauterpacht. And I think that makes her personally very supportive of doing the right thing on these issues. That's one of the reasons that the United Kingdom has been so supportive on issues of accountability. Again, it comes back to a theme that, infuses all of my writings, the vital role of individuals in all of these matters. That left the United States. Some of you will be aware that just last week, the State Department, through Beth Van Schaak, the Ambassador for War Crimes, made a very strong statement in relation to these issues. So where are we now? There is now very broad support by a core group of essentially WEOG countries, 35 or so, to create a special criminal tribunal for the crime of aggression. But what sort of tribunal? The Ukrainians want, supported by the Baltics and I believe Poland, the Czech Republic and some other countries, but none of the big power countries, an international tribunal of some sort, either created by treaty or created by agreement between Ukraine and the United Nations or a European institution. That follows, of course, the model of the special tribunal, for example, for Sierra Leone or Kosovo, which are referred to as internationalized tribunals, but in fact they have, I think it's fair to say, the status more like an international tribunal. That model at this point is not yet supported by the big four, if we can call them that. Well, I don't really like calling them that, but let's call them that. They would rather prefer a sort of an extension of Ukrainian jurisdiction into an international office with some maybe international prosecutors and international judges. But essentially, and this now is me expressing my view on what's happening rather than any official view, are absolutely concerned about the precedent that is about to be established. What is concentrating their minds, and it's not an unreasonable point to take, if you can create a special criminal tribunal today in relation to Russia, a permanent member of the Security Council, why can't you create one tomorrow in relation to us? And I think if you put yourself in their position, that is what is motivating the anxieties and why they would like effectively to settle on a sort of national plus kind of tribunal which of course has all sorts of implications for a number of things, including the question of immunity. So that is the position where we are now. There is broad support for some sort of internationalized tribunal, but some countries want to go further and have a full international tribunal. And the debate is now focused on this. And I think it's in this area that the Council of Europe and the Reykjavik meeting can have a very significant role. We are, I think, in grave danger here if we do not, in the European context at least, support accountability for the crime of aggression, of losing the crime of aggression forever. This is the very same area in which the horrors of the 1930s and 1940s occurred. Never again was the language of Nuremberg. The crime of aggression, crimes against peace, was central in the Nuremberg process. There has not been a use of force on such a scale in the European context since 1945. Are we really going to let this pass simply because a small number of countries are worried that they may become ensnared in the future? That is the central issue. Against that background, there is another point which I think must be made, and it is that the global South has not yet shown itself supportive generally of Ukraine's situation, but also in relation to the creation of a special criminal tribunal. So there are a number of countries, Liechtenstein leading the fray, who would like a UN General Assembly resolution in the absence of a UN Security Council mandate, which of course is impossible because there'll be a Russian veto. But a resolution, of course, would have to achieve the support of many global South countries. And I think there is a question as to whether Ukraine and its allies at this point have paid enough attention to the global South. Interestingly, and Africa here is very important, Africa is the only region in the world to have an international tribunal with jurisdiction over the crime of aggression, although it has not yet entered, I think, fully into force, with only 15 out of the 55 or so African countries having ratified the relevant instrument. So that's all by way of context and background. Now let us bring ourselves to the relationship between aggression and the other crimes. I regret very much that my friend and former student, the prosecutor of the International Criminal Court, is at this point still not in favor of a special criminal tribunal for the crime of aggression. My reading of the situation is that this is not an issue of principle, but an anxiety that if we were to create such a tribunal, it would somehow deflect from the attention, the force, the mandate, the scope of jurisdiction, and the money going to the International Criminal Court. I think that's completely wrong. A special court on the crime of aggression can be set up at really small cost compared to the costs of investigating war crimes and crimes against humanity, because the crime of aggression is just so much easier to prove and establish. You're basically talking about a dozen people in an institution that can deal with this, I think, fairly expeditiously. The prosecutor of the ICC, as we all know, has recently issued his first indictment and arrest warrants in relation to what is happening in Russia. It is very limited in terms of the criminal activity alleged, the deportation of children from the territory of Ukraine to the territory of Russia, and it is focused on two individuals, one of whom happens to be the president of Russia. My reading of what has happened here is that it is very likely that the ICC prosecutor focused on one or more crimes in which he could ensnare Mr. Putin precisely as a way to head off a special tribunal on the crime of aggression. Because one of the arguments for the crime of aggression is it's the only one that gets you straight to the top table. And I suspect that part of the strategy has been, look, we don't need to deal with aggression to get to Mr. Putin. Now, I don't buy that argument, But I'm also a little bit concerned if this issue is now beginning to influence and inform the direction of the ICC. I was surprised that that arrest warrant was made public. I noticed the statement of the president, who happens, of course, to be a Polish judge. I was very surprised by that video statement. That is extremely unusual. My own sense is that there could have been some justification for keeping the arrest warrant sealed, to keep people guessing as to what was happening. But it's plain that within the ICC, there has been a desire to say we can go straight to the top. And I think that is probably intended to do what I had suggested it was done. I suspect also that the prosecutor will have gone to the pretrial chamber with other crimes, and that the pretrial chamber will have determined that there was insufficient evidence at that point to allow a reasonable case to be made for the direct and personal involvement and responsibility under criminal law for Mr. Putin. It just strikes me as really odd, of all the crimes to go for the deportation of children. I'm a parent. I have 3 children. I care passionately about children. This is an appalling story, and I completely support the ICC's investigation of this issue, and the matter must be dealt with and must be subject to accountability. But of all the things that are going on right now in Ukraine, is that really the number one object, given some of the allegations and evidence and information we are seeing of the horrors on the ground, the targeting of civilian infrastructure, the killing on a wide scale of civilians, the massive use of military hardware in relation to civilian populations, the allegations of torture, of killings, of disappearances on a very, very large scale. The ICC has not yet addressed those issues, and that is a matter of concern. So to wrap up, if I go back to that moment just over a year ago where I wrote that first article, and I wrote a second one, if you like, on the anniversary, I'm surprised by the extent of the progress that has been made. My sense is that there will be some sort of special criminal tribunal created. President Zelensky, who is visiting Poland, I think today, made a statement just 3 or 4 days ago in which he said clearly he would not accept a hybrid tribunal. He would not accept an extension of a Ukrainian national criminal instance into the international level. There is a problem under the constitution of Ukraine in any event with doing that, but he wants, and I think he is entitled to, some sort of a proper international tribunal. And so the battleground going forward, and the reason that I'm doing this particular podcast, out of the many invitations that I get, is I think Poland has a particularly special role on this issue because of its history and association with the invention of international crimes, because it knows firsthand from what has happened on its own territory of the horrors of some of these crimes going back to September 1939. And because it has very strongly and courageously, I think, pushed for accountability and justice across the spectrum of international crimes, but also in relation to the crime of aggression, I think Poland's role in this process within the Council of Europe and elsewhere is hugely important. So very considerable progress over the last year. Crime of aggression is certainly not dead. It's got a strong and beating heart, but there is work to be done on bridging the gap between the views of the countries most geographically directly affected by what is going on and the big powers, so to speak, the big four. And I think that's the challenge ahead. My own reading is that the position of the big four and the G7 to go for what they call a hybrid or internationalized tribunal, essentially a national extension, is just a first bid. They have moved a considerable way along, and it will be very interesting to see what comes next. Why don't I stop there and let's throw it open to the discussion and the conversation. Thank you so much for the invitation. I've truly appreciated it.
Professor Sanz, thank you very much. We are really honored that you have decided not only to devote your time to our webinar, but also to say so important things and to be so relevant to actual events, including the visit of President Zelensky to Poland happening today and tomorrow. We know that you have to leave us in approximately 22 minutes from now on. So now the original plan was to listen to comments by two speakers, by Paula Fischer and by Kristaps Stamus, but maybe I would like them to ask you first questions in order to give you some opportunity to maybe to reflect on some of their views, and later on they will provide for more comprehensive comment to your speech. So maybe Dr. Paula Fischer from the University of Cologne, Academy of European Human Rights Protection goes first. Paula, floor is yours.
Thank you very much, Adam. And thank you, Professor Sanz. This was an exceptional speech. I'm still in my head with a lot of questions that I could ask you, but I will start with a very basic one. What do you reply to the argument that we now have a different setting in the international criminal international scene, now that we have the ICC, and that we have a limited jurisdictional regime on the crime of aggression? It's just possible legally to now create a special tribunal on the crime of aggression.
Well, we do have a different scenario. I mean, I think we're all aware of the difficulties with the International Criminal Court. I'm very strongly supportive of the institution. I was in Rome in 1998. I want to see it succeed. I do worry about putting all our eggs in that basket. I don't buy the argument that to support a special criminal tribunal for the crime of aggression is to undermine the ICC. Quite the opposite. I do think as we move forward with the crime of aggression, it's very important to emphasize two things. Firstly, it should be done in cooperation with the ICC. That's one of the reasons I regret that the prosecutor seems to have turned his back on the crime of aggression. It makes it much more difficult for that cooperation to be done when you've got a key individual like that belly aching against the crime of aggression. Secondly, I think it should also be used to revisit and to strengthen such jurisdiction as the ICC has on the crime of aggression. I'm talking, of course, to the Kampala amendments and the materials, which are far from perfect. I think stepping back, we can see that this issue is part of a bigger debate about the place of the crime of aggression in the spectrum of international criminal justice. I have to say I'd be very concerned to see the crime of aggression falling out of that spectrum. If you go to the work of the International Law Commission last year, you will see that they, in their work on immunities, have effectively downgraded the crime of aggression. That really bothers me. What happened in 1945 was a central moment. I've always thought that war and the waging of an illegal war is absolutely something that our international criminal justice system needs to deal with. And I'm really seeing slippage on this. And so one way to look at the position of the US, the UK, and France and Germany is that by downgrading the kind of institution they want to have deal with this, they are effectively signaling the death knell of the crime of aggression, a big step back since 1945. And I think that's really what is in play. And I think at moments like this, responsible leaders need to be asking themselves the big questions. And the big question is not only what do we do now, but what sort of world do we want to live in the future? I want to live in a world in which war is outlawed, and the criminal justice system is part of that act of outlawing. And I'm worrying about the slippage. That's too why I hope the ICC prosecutor can be encouraged to shift to a more cooperative position, precisely so that whatever emerges, and I'm pretty sure there will be some sort of a special criminal tribunal on the crime of aggression, that it is cooperative, supportive of the International Criminal Court. But I don't want to put all my eggs in the ICC basket.
Thank you very much. Paula, is it the only question of yours, or maybe some more?
Well, I think it should be Christoph to
Yeah,
step in.
okay,
Just maybe
so-
one.
Okay.
Okay, maybe just one very quick question that came up to me when you spoke, and also in your reply. Why Germany? Why is Germany in line with its Western partners? Because Germany has ratified the Kampala Amendment. It has been a very strong voice in the negotiation on the crime of aggression, and it has a particular history about the crime of aggression precisely.
Yeah.
Why is it partnering with the hesitants and the hesitators of France and UK?
That's a really big question, and I suspect you and other colleagues with a closer German background will have a better ability to answer that than me. This is, I think, in part, they don't want to split with France, and this is something France feels very strongly about. And I understand that. If they break with France, there is a fracture. And I think the German-French alliance is one of the reasons why Ursula von der Leyen, it's another part of the picture that I should have mentioned, has proposed, and it's now in the course of being established, of a centre on the gathering of evidence for the crime of aggression, which is being created in The Hague. I mean, I don't think it's going to be hugely complex work, because crime of aggression is really easy to establish, I think, in this case. And I think that's the main answer. But of course, and you'll know far better than I, Germany is particularly exposed economically and in terms of energy to the situation in Russia. I'm actually speaking to you from France, in a small village in the Luberon, and I had dinner a couple of nights ago with a friend in Germany who pointed out to me the couple sitting in the corner of the restaurant, Oscar Lafontaine and his wife, the leader of Die Linke. And we then had a very interesting conversation about their position on all these issues. And it was fascinating. I mean, they're really basically supportive of Russia. At least they don't want to cause a big stink. They want to be able to slip seamlessly back, it seems, into an economic relationship. What my friend said to me, and she is extremely well connected, is that across the political spectrum in Germany, politicians have been lining their pockets with support from Russia. There is here a deep personal connection. I don't have firsthand evidence of this. I don't have information about this. And lest I'm accused of anti-German rhetoric, which I hope I won't be, I think the situation is exactly the same in the United Kingdom, which of course welcomed massive inflows of Russian money. London became, Londonistan over many years. And so there are a raft of countries, I think, which have been led by people who have been beneficiaries of Russian largesse, shall we say, and find it rather hard to put the accent now on the individuals who are responsible for these horrors. That's what I think probably is going on, and so they are hesitant. But I think there's tremendous appetite in public opinion for doing justice on these things. And if you talk about justice without the crime of aggression, in my view, is not justice at all, because it's going to lead the people at the top table completely to be off the hook, and that would be a travesty of what I think many people on this call actually believe in and supporting. But you'll know better than I the details. But I suspect, judging by your reactions, I'm not completely off the mark in terms of my theories about what's going on here.
Thank you very much, Professor Sanz. So now I would like to ask Kristaps Tamus for giving his question.
Yes, thank you very much, Professor Bodnar, and thank you very much, Professor Sanz, for your extremely insightful behind-the-scenes discussion of what is happening. It puts a different perspective of things that we read in official papers and so on.
There's more that I could tell you, but then I would have to kill you.
Sure, we don't want that. But my question will be, maybe it will sound technical, but the purpose of it is to make sure that whatever initiatives we are discussing do not end up with the responsible persons escaping liability on technicalities. And so my question, first, I would formulate it similarly as Paula began her question, whether the ad hoc international tribunal can be established without changing the existing architecture of international law. But the direction I'm going to is slightly different. It's about where do you find crime of aggression? You were, I think, deliberately non-specific about it. You mentioned the phrase that crime of aggression is out there, and then you spoke about invention of international crimes. And in terms of foreseeability and predictability and non-reversibility of international criminal law, where would the International Tribunal find the crime of aggression? How would Putin be able not to argue that, well, I couldn't predict that I would be charged with this?
Really, really good question, and I can assure you, we're a sort of little group of colleagues who've been reflecting on this for a year. You'll know many of them: Klaus Kress, who has been just excellent, Alex Whiting, Dapo Akande, Carrie McDougall. So your question is one, I mean, I could spend hours talking about it. I mean, you've got a number of sources of obligation. I mean, if you go back to 1945, of course, what then happened is that the judgment of Nuremberg, which was based on crimes against peace, went to the General Assembly of the United Nations, resolutions 95 and 96, and that resolution said that what the court had said reflected international law. We know that crimes against peace was literally invented in the summer of 1945 and was applied, frankly, retroactively to events that occurred prior to the crystallization into a real international legal obligation of a general rule of international law. But since 1946, I think you can argue that the prohibition on the use of force has become part of general international law, and the concomitant emergence of international criminal rules has also become part of general international law. What remains much more difficult, of course, is what is an act of aggression under international law. You've got the 1974 definition adopted by the General Assembly, you've got the ICC definition, you've got various other definitions, you've got the definitions in the laws of Russia, Belarus, and Ukraine. In our own discussions within our group, I think because, this comes back to Paula's point, because we think it is very important that whatever is done is consistent with the work of the ICC going forward and supportive rather than contradictory, it would be ideal to take the ICC definition, as also developed in Kampala in terms of the substance. And on that issue, interestingly, although Russia has not, of course, is not a part of the ICC, has not supported the Kampala Declaration as such, it's been very interesting hearing from Klaus and Carrie, who were very actively involved in those negotiations, that the Russians not only didn't object, but they supported it. And so I think you can find a source of legal obligations, which is a sort of melding of resolution on aggression of 74, Nuremberg, the ICC, and the domestic rules within the legal order of those three countries. I mean, in an idealized world, you would go, I think, for a sort of global type of definition and a global institution supported by the United Nations. But if the political will isn't there for that in the global south, then you'd have to have a European, a regional approach. There's no problem with a regional approach. And I don't think I've got any difficulty arguing that within the European context, in which I include Russia, there's a regional custom. There is a general acceptance of the concept of aggression under international law and the criminalization. And it brings us back to the irony of the summer of 1945. Which country put the crime of aggression into international law? Russia, the Soviet Union, the predecessor state. And so I think it's going to be pretty difficult for Russia to argue that they don't accept a sort of general international law definition of the crime of aggression. But your point, of course, is a very important one. And we've been spending quite a lot of time thinking about that. And I'm sharing with you there roughly where we've settled. But open to all ideas, as always.
Thank you, Kristaps. And I think we have still 5 minutes. Okay, so maybe if short question.
Yeah, next one will be more of a softball question, challenging.
How do we get Mr. Putin?
That's the easy question. Now, my question is, what is your position on war crimes and crimes against the humanity? What is the proper court or tribunal to deal with those? Is it ICC? Because we have seen that ICC is quite inefficient in many ways, even though it's getting more support now. Or could these be entrusted to, I don't know, an extended Ukrainian jurisdiction and so on?
Well, Philip, before you start, can we take also a question from Andrew Jemczewski?
Yes, my good friend Andrew, Andrew nearly 40 years.
Yeah, Andrew, please go on. I think Andrew was surprised a little bit. Okay, so maybe Professor Sands, maybe we'll talk with Andrew later on. So please go on with a question by Kristaps.
So remind me of the end bit of the question, Christopher. Just while I was watching Andrew, I just forgot exactly what the end bit of your question was.
Yeah, which is the more
Look, I do think that the ICC's approach to the principle of complementarity is right. It has to be first and foremost for the Ukrainian authorities to determine whether they are able to exercise jurisdiction over particular individuals. And the ICC can only exercise jurisdiction as and when the state concerned has shown itself unwilling or unable. And I have to assume, well, I know that Ukraine is comfortable with the ICC proceeding with the crime that it is proceeding with in relation to the deportation of children. I suspect there'll be a pretty delicate and difficult negotiation between the ICC and Ukraine. And of course, other countries too can exercise jurisdiction. This is pretty significant, including on aggression, in relation to people who come within their jurisdiction, if they travel and if they are found there. Germany, Poland, one hears various stories about the possible exercise of jurisdiction. I think this question has to be put also in its broader geopolitical context. The ICC has a problem. If you go onto the website of the ICC, you will see that pretty much everyone who's been indicted and prosecuted is Black and from Africa. And the ICC has a race problem and has a geographic distribution problem. And so along comes the war in Ukraine, and helpfully for the ICC, we've got lots of white people, blonde people, often with blue eyes, who can suddenly be the subject of investigation, indictment, arrest, and so on and so forth. And the ICC has got to be seen to deliver. But I think there is a problem right now. The Global South perceives what is happening as the ICC as a prosecutor's office having been captured by a small number of countries. I personally don't think an ICC prosecutor should be doing photo opportunities with ministers from certain countries and not others. And if you talk to your friends in the Global South, and I do a lot of work in Africa and South America, they're pretty appalled by these photographs that show prosecutor or the prosecutor's office sort of cavorting with British ministers, French ministers, German ministers, Polish ministers. And the signal that sends out is not a happy signal for other parts of the world. And I think in relation to your question, which I know wasn't focused on that aspect, I'm pretty concerned about that. It's a global institution and it must not be seen to be in the pocket of any particular country. It's also an institution which will have to investigate Ukrainian crimes if Ukrainian crimes are being perpetrated, which makes the cooperation with Ukraine, of course, pretty problematic. I'm not suggesting that there have been Ukrainian crimes or that if they have, they're on a scale with what Russia is responsible for. What I'm saying is the long-term well-being of the ICC is dependent upon it sticking firmly to its rules-based system and maintaining its independence and impartiality and not being seen as a puppet of any particular government or governments. And I think that is in issue right now, and we need to proceed very, very carefully as we go forward. I appreciate that my comments on that will not receive universal support and encouragement, but as you know, Adam, I do like to call a spade a spade. And I think we have to talk about these things because from our cozy European context, the vista is one thing. From other parts of the world, it's very different.
Thank you very much for your integrity, for your honesty, intellectual eagerness to share with us different perspectives, and also reminding us about the ethics of different service and taking into account just this, as you put it, global perspective of looking at certain things. Professor Sanz, we are really grateful for your time. We do not want to take too much of your time because, as I understand, you have some other responsibilities. So let us allow to continue, and we'll discuss on your views and on your positions further on. So thank you very much for being with us.
Thank you very much.
Thank you. Ladies and gentlemen, now I would like to ask Dr. Rein Fischer from Academy of European Human Rights Law Protection to take a floor for 5 minutes, maybe 7 minutes, in order to present her position regarding the topic that we are discussing. Later on, we'll go into Kristaps Stamu's presentation, and then I'll open the floor for the discussion of all the people who are with us in the room.
Thank you, Adam. I'm trying to be brief. First of all, thank you for this opportunity to comment and to give this short view of what I think it could be the role of the Council of Europe in shaping the accountability mechanisms. And this was also a question in the chat. I think that we haven't yet dealt with really what is the role of the Council of Europe in that respect. So I think I'm concentrating mainly on also the aspect that Philip has only touched upon, which is the criminal justice part, because we know that there's another accountability possibility, which is the issue of reparation. But I will leave that out for the moment, and maybe we have some time for in the discussion to come back to that. Interestingly, in all the documents and resolutions and decisions by the Council of Europe organs, we see a clear call for the setting up of the Special International Criminal Tribunal for the crime of aggression, and even a calling on member states, international organizations, and Council of Europe to provide human and financial resources, expert and technical assistance and technical support to that tribunal, and also already to an interim international prosecutor's office to investigate the crime of aggression. So we have a clear stance by the Council of Europe already in favor of that tribunal. And of course, the question is how can this actually be concretely implemented? And regarding that special tribunal, especially if one favors the idea of that special tribunal, which I do as Professor Sanz does, because I think the crime of aggression is it's the starting point, as he has said. I think it is just necessary that the Council of Europe takes a stance in favor of the tribunal and supports that step as best as it can. And the precise way of how the Council of Europe can do so will, of course, depend on the exact shaping of that tribunal, whether it is established as a truly international court. Philip Sands has mentioned the precedents of Kosovo and Sierra Leone, but of course we also have the precedent of Nuremberg, and he has also touched upon that, or whether we have a hybrid tribunal based rather on Ukrainian law. While I share his concern that this, of course, would raise it would be a pity in view of the fact that we would have personal immunity applying in that case. Interestingly, in theory, one could also think of a special tribunal set up under the auspices of the Council of Europe as such, for example, created by the Committee of Ministers or by an agreement between Ukraine and the Council of Europe. However, in my view, the UN seems more suitable forum in view of the larger number of states being represented there, including Russia. So I think it is very understandable that this criminal tribunal under the auspices of the COE has never been seriously discussed so far. So what's exactly the way the Council of Europe can now contribute to that establishment and the successful implementation of the criminal proceedings before such a tribunal? First of all, I think one aspect that is very often overlooked is that the Council of Europe can influence customary international law to the benefit of the proceedings by explicitly setting out a specific opinio juris, especially regarding those areas of international criminal law that are still disputed by some. And Philip Sands has already touched upon the most important aspect, which is the personal immunities aspect, in my view, of incumbent heads of state, so the Troika, that the Council of Europe can take a firm stance saying that there is no such immunity, that there's an exception of such immunity. And it has already hinted in that direction in one of the Parliamentary Assembly resolutions end of January 2023. Another very important point that Chris has raised is the jurisdiction ratione temporis for the crime of aggression, and that the Council of Europe should try to refute already the claim that has also been made in Nuremberg that a conviction for the crime of aggression would be a retroactive criminal justice. So I think also here the Council of Europe can influence customary international law. And then finally, also interestingly, already present in the Parliamentary Assembly resolution of January 2023, is the idea that there may be potential limitations on the right veto within the UN Security Council, because in case of an abuse of that right, this veto might not be valid. So this is another aspect, an area where I see that the customary international law could be changing. Secondly, apart from that aspect of customary international law, of course, the Council of Europe should verbally support that tribunal to enhance its legitimacy. And this is a concern that is especially important with regard to a hybrid tribunal established under the Ukrainian law, because that concern is very much attached to that idea, because a hybrid tribunal established under Ukrainian law would not have the same legitimacy as a UN tribunal. And then more concretely, how could practical support look like? And here we have an information document by the Secretary General that is already quite detailed and that I find quite convincing in many respects. So first of all, the Council of Europe should render legal and technical assistance to the now established International Center for the Prosecution of the Crime of Aggression, the ICPA, which is the result of the Uniting for Peace conference in Lviv 1 month ago, and whose mandate is to precisely investigate the crime of aggression and hence prepare criminal proceedings. So the support should take the form, in my view, of strategic legal expert advice. Then the Council of Europe should help building capacities and gives technical assistance to investigation and documentation of crimes. And it should also help building capacities of first-line professionals working with the victims of violence, including sexual violence. And similar technical and legal assistance should be given to the preparation and setting up of the tribunal as such, which would then take the form of assistance in selection and appointment of judges, but also the elaboration of rules of evidence and procedure, unless we decide, or the tribunal will use the rules of the ICC itself, and then the technical and legal support of the case management. One last remark that I want to, and then I want to limit myself, is the support of the ICC, and Philip Sands has already pointed to that relationship between the two courts, and I found that very interesting. That in his view, the ICC has really already is about to turn the back to the idea of a special tribunal. In my view, it is indeed of primary importance to enhance a close cooperation between these two courts, a respective court and tribunal. And one idea that has been raised, and which I find convincing, is that the tribunals should even share evidence and align their agendas regarding the defendants and witnesses, so as to achieve synergies and exclude legal problems such as conflicting legal effects, and to respect the nebis in idem principle. At the same time, and this is where I see some problem, a too close cooperation between those two courts risks of feeding the criticism that the special tribunal is ultimately just a branch of the ICC, and it's just a tool to circumvent the limitations of the ICC's jurisdiction. So in my view, there should be a good balance between cooperation and an adequate distance of both courts. And then finally, regarding the ICC, and also this is a point that Philip Sands has mentioned, the Council of Europe should make another important contribution, which should be the flip side of its support for the special tribunal, namely, it should increase pressure on its own members to finally ratify the Kampala amendments on the crime of aggression. And this is, of course, an aspect that primarily concerns France and Britain, which have been one of the very, very slow forces and slowest to forces to really, they are the reason why we have such a limited regime under the ICC jurisdiction rules. So secondly, apart from that, pressure that this Council of Europe should put on those members to ratify the Kampala amendments, the Council of Europe, in my view, should also work towards an amendment of the rules of the Rome Statute as such. And this is also an idea that is already present in the parliamentary resolution of January 2023. So this could be done, for example, more concretely, I think, for example, by a resolution that could explicitly name those members that have not yet ratified the Kampala amendments, but also, of course, through diplomatic conversation. And I said I will leave out the point of reparations, so we might come back to that issue later on. Thank you.
Okay, thank you very much, Paula, for your contribution and for very important suggestions that the Council of Europe especially may do, because I think in the context of upcoming summit, it is especially relevant what to put into the Reykjavik Declaration. We have here with us Harry Hummel, who is representing the Campaign to Uphold Rights in Europe. So Harry spent a lot of time on and his team on preparation of so-called Hague Civil Society Declaration and such, I would say, additional backing and ideas for what the civil society or scholarship should suggest to be included in the Reykjavik Declaration. I think it's extremely relevant. Kristaps, now the floor is yours.
Thank you very much. And it's difficult to speak after Paula because she already managed to cover most of the points I was intending to cover. But I will maybe try a little bit different approach and the way I comment on the way that I started thinking about this topic. So when I posted an announcement of this event on Facebook, a friend of mine commented with a question: why should it be the Council of Europe dealing with it instead of some richer and more involved organization, for instance, the EU? So when I started thinking about it, I was focusing on exactly what are the strengths of the Council of Europe and what could the Council of Europe contribute to this. And as Paula, I will focus mostly on Professor Sands' take and focus on the tribunal with regard to crime of aggression, even though I do think that the international compensation mechanism is a fantastic idea and to which the existing Council of Europe resources could contribute the most. That's the area where the contribution of Council of Europe would be invaluable, actually. So turning to the issue of international tribunal, first strength that the Council of Europe brings, it actually brings from the area of European Court of Human Rights, and namely the standards that the court has established in its consistent case law over many, many years. And those standards apply to many of the issues that we have discussed and that Professor Sands, as he named it, put as markers. And for instance, the question of immunity or the question of jurisdiction or retroactivity. Those are all issues that have already been discussed extensively in the case law of the European Court. And in this respect, I'm slightly skeptical about Paul's suggestion of Council of Europe being the initiator of changing of customary international law. Because in my view, this again brings us to the issue of retroactivity. You don't change the rules after the game. And repeating again, this is my idea is that we should do everything possible to avoid failure of this international criminal responsibility because of technicalities. So why I'm critical of the idea of the customary international law, because I think that there are answers to all the problem issues already in the case law of the court, and how this information could be used. I think this is where the Council of Europe comes into play. So, of course, in the resolution of the Parliamentary Assembly of January 2023, it is both the member states of the Council of Europe and the Council of Europe itself, which is being called upon to provide legal and technical assistance in establishing of international ad hoc tribunal for the crime of aggression. And specifically, this legal and technical assistance from the side of Council of Europe could focus exactly on the drafting of both the substantive rules that are going to be applied and the procedural rules that are going to be applied, strictly not in line with the case law of the European Court of Human Rights. And so this I see as the major contribution that the Council could be making. Secondly, Professor Sands focused a lot on sort of realpolitik issue of getting states voting to vote one way or the other. And that is the second area where the Council of Europe has a huge advantage over, for instance, the European Union, taking into account its extended number of member states. So this is, Council of Europe is a large but reasonably efficient political platform for political discussions. So these negotiations that now seem to be taking place behind the scenes or in little bars in France, they could be taking place openly within the context of Council of Europe, especially if the Reykjavik summit declaration actually does end up including many of the proposals that are there. Then these proposals could be just the start for more or less technical discussion that could take place between the Council of Europe member states, which do include a significant number of states that are not EU member states, but still have significant experience and significant opinions with regard to how these aims of achieving criminal responsibility could be achieved. Lastly, I wanted to turn to some of the problems that Council of Europe is having with regard to its involvement in this process. And the first problem is the most obvious one, that Council of Europe does not have money. And so if ambitious initiatives are being put into Reykjavik Declaration, there will be technical and legal support and drafting this and contributing to this, then there should be sufficient financial backing from the member states as well. because otherwise this will be inefficient, and because as we discussed last time, this is what's happening to the court. And the second issue is perhaps more significant, but perhaps not so significant at all. This is the issue of the court's case law with regard to wars and armed conflicts. And this is the widely criticized approach of the court in the Georgia versus Russia case, where the court spoke of the fog of war and chaos of war, which prevents the establishment of what actually happened there and so on. So if we were to take this approach for the real legal principles that are to be applicable, then perhaps the court's case law would not be so helpful at all. However, I would like to quote my former colleague from the court, Gayanan Nurijanyan, who has said about the war in Ukraine as one of the best documented armed conflicts in history. So in this way, perhaps we get around the problematic issues of Georgia versus Russia decision. At the same time, we follow the recent admissibility decision in the MH17 case, where the fog of war is being lifted, and the court is actually dealing in detail with this highly detailed evidence that has been gathered throughout the time of the Russian aggression against Ukraine. And in this situation, the role of Council of Europe and the staff of the court and the technical capacities of the court might be linked also to gathering and systematizing this evidence that is already available, and as Paula suggested, making it available to the tribunal that is going to be set up, or SEC, or something along those lines. I hope we'll get a chance to talk about the compensation mechanism as well, but I will leave it with that at this point.
Thank you, Kristaps, for your contribution, for your comment. I can only regret that Professor Sands could not listen to the whole speech of yours as well as a speech of Paula, but you know, these are those circumstances of people that are extremely busy. And as we understand, a lot of people and institutions need the voice of Professor Sands. I would like to give the floor now to finally to Andrew Jemczewski, who, because of our technical problems, could not speak for the first time. Andrew, could you please take the floor, please?
Okay, the mic's on this time, thanks. Can you all hear me?
Yes, everything is fine.
Most kind, thank you. Good afternoon, everyone. I was going to ask Philip, and perhaps now all the panelists, your views on the Council of Europe's initiative to establish, by means of an enlarged partial agreement, which will be set up by the interested member states, Council of Europe observers, and possibly the European Union, of a register of damage caused by the aggression of the Russian Federation against the Ukraine, which is to be based at The Hague with a possible antenna in Kiev. And I was going to put a damper on what Philip Sands said with respect to Poland's role concerning the run-up to and in Reykjavik. I think there's a problem with Poland in the sense that Poland has indicated to the court that it's not prepared to abide by interim measures of the court. Does that put it in a good position with respect to influencing preparation for Reykjavik? And possibly worse still, I would say that the Polish authorities' apparent readiness not to comply with important Strasbourg court judgments, following two judgments of the Polish captured Constitutional Tribunal, where they instruct, or the Polish Constitutional Tribunal indicates that the Strasbourg court judgments with respect to certain rule of law issues should not be complied with. So please, I think one should bear this in mind, and I think I'll leave it at that. Thank you.
Thank you very much. I think we'll collect questions, maybe. So now I would like to ask Harry Hummel, from the Campaign to Uphold Rights in Europe. I mentioned that this campaign, CURE Network, has prepared this Hague Civil Society Declaration for the upcoming Council of Europe Summit. Harry?
Thank you very much, Adam. I'm sorry, I don't have. My video is not working, the camera is not working, so you have to do without my face. I am, thank you also for mentioning the work of the CURE campaign and the Hague Civil Society Summit that we held a month ago. The declaration that was the result of this conference does not specifically mention Ukraine situation. There's a separate statement on Ukraine. The declaration itself focuses on structural strengthening of the Council of Europe in a number of ways. And what I'm going to say now is kind of an elaboration of the same thinking, with respect to but then focused on what the Council of Europe could do with respect to Ukraine. I have been quite surprised about the lack of innovative thinking and the lack of daring thinking from the side of Council of Europe bodies on how to deal with the war of aggression against Ukraine. If you call this watershed in history, these kind of terms have been used by many observers and experts, then you should act according to, you should create new realities in legal and in political terms, and in terms that are, that befit the Council of Europe. In that respect, I would argue that, dealing with the Russian aggression in an appropriate way is fully on the plate of the Council of Europe. I see two strands of possible action. One would be maybe under the European Convention of Human Rights as it is, but that, there are interstate complaints, I think several of Ukraine against Russia, dating from the period that Russia was still covered by the European Convention of Human Rights. It was still a Council of Europe member. So between the start of the aggression and the 13th or 15th of March last year, this offers a lot of opportunity, I think, for the court, even with its relatively restrictive interpretation of its jurisdiction in times of war, to say things about the Russian operations in Ukraine. One step further would be to look at the fundamental Russian breach of the Council of Europe Statute, which is an international treaty. It has no explicit, rules in the statute about what happens when you violate the statute, except, of course, indeed, that in the end you can be thrown out of the arrangement, which was what happened. But there is, Russia was bound by the standards of the Statute of the Council of Europe, and it should bear responsibility for, violating the statute in a fundamental way. And I would argue that the Russian aggression against Ukraine, is such a fundamental breach, and that they could expect to be held accountable for, the acts that they committed. Now, of course, this is state responsibility. It is not individual responsibility, which we are talking about when we talk about the ICC and when we talk about the special tribunal on aggression. It would be a step for the Council of Europe to kind of start harboring a special tribunal where individuals would be tried for the crime of aggression. But I would argue that it is not, that it is an appropriate step in the current circumstances. Much of the rest of the world resents kind of in a way being expected to take steps under the UN, under UN arrangements or on the basis of UN decision making, all of a sudden by the Europeans, because a crime of aggression and horrific violations of international law have started happening in Europe. They see this as a one-sided approach, and I can understand this. This, in my view, leads to an argument that the Europeans should do it themselves, amongst themselves. And there the Council of Europe clearly is the most appropriate body. What is needed is leadership, either from the leadership of the Council of Europe itself, the Council of Europe bodies, Secretary General, or from Parliamentary Assembly, or from a number of states. And there, the problem, as I see it, is that these states that are member of the Council of Europe is a too amorphous, abstract, concept. None of these states, or hardly any of these states, wants to stick their neck out and show the type of leadership that is needed in, a period of big upheaval in international relations. It may be already be too late, because all the discussion has gone in different directions. The Council of Europe has not shown it is capable of, taking on board in an appropriate way the effects of the fundamental disruption of the European order by Russia. It may not be too late yet, but I don't see this happening in Reykjavik. So, but I would like to hear your opinions.
Thank you, Mr. Hummel, for your question. There are also a couple of questions in the chat from Madame Christina Trichlip, and maybe I would like just to ask you, our commentators, to answer one of them. Are there any sanctions, legal consequences envisaged for non-compliance with arrest warrant issued by the ICC? So can this warrant be just ignored, or are there any sanctions if some states that ratify the Rome Statute do not follow this arrest warrant in case of having, being somewhere close to Madame Ombudsman for Children or Mr. Putin? I don't see any further question, it seems to me. So maybe now I would like to give the floor to Paula and then Kristaps.
Yes, thank you. Thank you for the questions and the remarks, and thank you, Kristaps, for your intervention. Very interesting what you raised. I may start with the aspect that has just been mentioned by Harry Hummel. In my view, I'm not sure whether I agree. I don't think that the Council of Europe should be the primary spot for the criminal prosecution, at least. Simply for the reasons that I've already pointed to. I think a UN established special tribunal, or at least a tribunal that has the largest possible legitimacy, would just be more beneficial, because it would precisely not have the stigma of being a Western European court, possibly even adjudicating now on the crime of aggression, while at the same time Western European leaders themselves do not subscribe to the jurisdiction of the crime of aggression under the ICC statute. So I think if we establish the special tribunal, it should have the largest possible ground. Regarding the other idea that you raised in holding accountable Russia for breaching the Council of Europe statute, certainly it has breached the statute, but what would be the consequence then? I think this idea of compensation is an aspect that we haven't really touched upon at all at the moment. So it's also related to the question by Andrew. So I might just say something on that because you asked for the register of damages. I think this is really the aspect, and Chris, I think you have said that as well. This is the matter where the Council of Europe is much more apt to take a lead role, in my view. Why? Because the Council of Europe has just much more experience with that than with criminal prosecution. The Council of Europe has never had a criminal prosecution tribunal. Why is it more apt to establish this register of damages? Because As we see, for example, in the experience of the ECTHR, the European Court, it has experience with examining the damages caused in conflicts, with evaluating evidence, with assessing claims. We even have the pilot judgment procedure. We have a large number of individual cases that are all kind of similar. So we can we have precedents, and we could use that experience much better here. Council, as I read the documents so far, or the opinions by the organs, by the relevant organs, they are also ready to take this leading role. And so I think the Council of Europe could even be the leading entity where this register of damages itself could be set up. One, because it covers much more states than for example, the EU does. I think that's an aspect that you also mentioned, Kristaps. And well, second, because it has much more experience than the EU with regard to these individual claims. The European, the Court of the CJEU is not comparable to the European Court of Human Rights. However, just one very brief aspect, because it's a discussion that is very much linked to that. We have the suggestion of a register of damages, but we have also the suggestion of putting up an international mechanism, which then itself would be something like a claims commission, because registering damages, that's the first step. This is something we can already do in the course of the war. However, at one point, we need also to adjudicate on the relevant claims and to ultimately enforce these awards. And this is a problem. This is a matter where I see many legal problems attached to that, because in my view, it is very unclear basis this claims commission or international mechanism that also the UN General Assembly has called for, on what basis this could be established, because the UN Security Council is not a viable option. The General Assembly cannot issue any binding decisions, binding for Russia. Then we have the idea of a multilateral treaty that could be the basis for that international mechanism. However, as we all know, multilateral treaties or treaties in general can never go to the detriment of third states which are non-party to that agreement. There is a provision in the Vienna Convention that some people have raised, that could be of help because it relates to the crime of aggression. But in my view, it's also not a clear-cut case. So I think we have some legal hurdles already to overcome in order to establish that tribunal, that claims commission. And even if we manage to do that, and this idea circling around and flowing around, this idea to have a fund and use central bank assets, especially, so state assets frozen in many European states. We have the clear problem of Russian state immunity that is protecting these very assets, and that would be circumvented otherwise. So just on this aspect, on the reparation and on the sanction question, maybe Kristaps, you're more maybe leave it here, and you can answer the last question as well. And of course, you will also refer to the other ones.
Thank you, Dr. Fischer, for your contribution, and Mr. Kristaps Tamuš, Riga Graduate School of Law.
Yes, thank you again. I have to speak after Paula, and she has said everything, but I will try to I'll try to add a few things. I will go in order. So with regard to the question asked by Professor Jemczewski, yeah, so this was something that was of particular note to me, this proposal of setting up the register of damages. And I see the role of Council of Europe in this as the most significant one, because the European Court of Human Rights is certainly has unprecedented experience in handling mass applications and systematizing them and making sense of them, basically. So this experience could and should certainly be used for setting up the register, as has been proposed by the Parliamentary Assembly. However, again, we run into the issue of the resources, because the court's resources are very stretched as they are now. And so maybe the involvement of the European Union, which is still a huge question mark, could assist with that. But yes, the court has fantastic IT systems and human resources that would be able to compile such a register in the most efficient manner possible. Turning to the idea of the claims tribunal and Paul's concern about affecting third parties which are not party to the treaty. Of course, this is potentially a sore spot, but the setting up of the tribunal, of a claims tribunal or compensation mechanism as such, does not need necessarily to negatively affect third parties. There could be a two-part agreement, one an institutional one setting up the mechanism itself, and a second one, making sure that the funds are produced in the claims tribunal. I think the second one is still too early to talk about at the present stage. But the first one, establishing a mechanism so people would know of its existence and would be able to provide documentation of damage done by the Russian aggression, can certainly be done at the present stage already, and hopefully the Reykjavik Declaration will focus on this aspect as well. With regard to Mr. Hammel's comments, I see the criticism of the Council of Europe and its, in a way, rigidity and so on. This criticism has been made time and time again. At the same time, I feel like it could be made with regard to any international institution which has more than 2 or 3 states in it. And if it has 40 plus states in it, then of course, any initiatives or daring has to come as a result of an implied or explicit consensus of all member states or majority of member states. And so the proposals that the Secretary General should be more daring might be on the edge of exceeding the mandate of Secretary General. With regard to the interstate cases pending before the European Court of Human Rights, well, they're still pending, and I'm quite certain that the court is working intensively on them, and we all anticipate the outcome of those cases. So, as you said, the jurisdiction and competence is still there. And lastly, with regard to the idea of Russia being held accountable for a fundamental breach of Council of Europe statute, I love that idea. I think it's a fantastic one, but this would require a lot of creative thinking legally on how this could be done, starting from the forum, ending with the consequences and all sorts of issues like that. But that certainly sounds like something that international law scholars could get their heads together about. With regard to the question from the chat, with regards to sanctions or legal consequences for failing to comply with the arrest warrant issued by the ICC. Well, this has been, as you know, a controversial issue ever since the issuance of arrest warrant for Mr. Bashir from Sudan, and him appearing in all sorts of ICC statute member states and not being arrested by them. So the first answer is that, as often in international law, there is no world police to come in and then punish somebody for failing to abide by arrest warrant. On the other hand, since this is a discussion that we are holding in the context of Council of Europe, I could see theoretical possibilities how failure to comply with an international obligation, and it is an explicit international obligation that derives from the ICC statute, could be seen as a violation of human rights. In terms of the state's obligation to prevent death torture, all sorts of other fundamental human rights violations. States do not only have an obligation not to engage in such violations, but also to prevent them. So one of the clear mechanisms of preventing such human rights violations is holding the responsible persons accountable. So accountability and lack of impunity are the things that drive people from to not do awful things. And I could technically see a legitimate complaint at the European Court of Human Rights under the convention in its existing state for failure by states to implement the ICC arrest warrant. Other than that, I hope that Professor Nussberger will be able to give us some useful insight into this.
Okay, so it's natural right now to ask Professor Nussberger, who raised her hand also. Angelika, please.
Yes, thank you. No, it's very innovative what you just said. It's a new path we might think about. I didn't want to comment on that. I just wanted to ask first to thank you for this very, very interesting and high-level discussion. But I just want to reflect with you on a little bit the dilemma situation of the Council of Europe vis-à-vis this idea of the special tribunal Philip Sands was talking about. Because on the one hand, of course, Council of Europe and Europe has a responsibility to support Ukraine intensively. But on the other hand, the question is it really supportive if the Council of Europe makes it its own issue? Because what Philip Sands said, and that's very important for me, it has to be universal. This tribunal. And in order to be universal, you have to avoid having this understanding that in the end, it's a European issue. And so I wonder if it's too much, if the Council of Europe steps too much sort of in the front line to make it its own sort of topic, I wonder if that's helpful in the end. And if it's not perhaps better to have a sort of, I would call it regional organization diplomacy. So for the Council of Europe to talk to its African and South American counterparts to get support from them, because that's what's missing right now. As we see, the Global South is not in, the South American countries are not in. And I wonder if we have not to go a little bit around the topic in order to be more successful than just to make it an only or a seemingly more European topic than universal topic. Thank you.
Okay, so one more question from, is there any other question? Maybe somebody just at this stage got inspiration to make some question. If not, then, please try to answer also this comment by Professor Nussberger with some maybe short comment, because it seems to me that we are running out of time. So maybe now Kristaps first, okay? Maybe we'll make this way.
Yeah, now again, it's difficult because I think we all three are in agreement with what Professor Nussberger was saying, that the Council of Europe has to be actually careful of not exceeding its mandate with regard to extremely innovative approaches, such as setting up tribunals and things like that, because the Council of Europe still remains an international organization set up by the consent of its member states, and it requires constant consent of member states for it to operate. Of course, if some sort of consensus could be achieved, then more radical measures could be considered, but it seems like no consensus has been reached yet. And with regard to the collaboration between Council of Europe and the counterparts in South America and Africa, that is absolutely a splendid idea, and I think there is already an ongoing collaboration between these institutions. And this could definitely be a useful forum where like-minded authorities from all over the world could be discussing and maybe raising awareness of the issues that are appearing. So yeah, I think fantastic ideas have been played around during this discussion. So Reykjavik Summit will have a lot of work to do to discuss our proposals.
Okay, and Paula.
Yes, well, thank you for this intervention. I completely agree. I think it's a dilemma that maybe we have also not yet pointed out so well before. And it's actually the same dilemma that we see with the decision by Karim Khan now to issue the arrest warrant with against Putin, and what Philip Sands has considered as something that might actually be detrimental to the foundation of the establishment of a special tribunal. So we see a sort of competition also between different actors. Who is the most supportive one, and in the end it might actually more be about the reputation of that organ than about the actual support that in the end reaches Maine. So I think this is why I'm so skeptical with regard to a tribunal, a criminal tribunal that would be established in the auspices of the Council of Europe itself. And I think it's been very wise of the Council of Europe to be more hesitant in this regard, and to only limit also itself to this technical support. However, I think with regard to the register of damages, I mean, we are in a struggle between using existing organizations and structures which are more efficient because they just were ready, and not, as you say, pulling too much of the focus also towards this organization, because, as I said, it should be a universal thing and not something that is too European. And this is also why I'm skeptical with regard to the idea of Mr. Hummel to now claim a breach of the statute of the Council of Europe, because it's not the first thing that comes up to us when we think about the war in Ukraine, that the statute of the Council of Europe has been violated. This is really not the problem, I think. The problem is that the prohibition to the use of force, and more importantly, the prohibition of aggression has been violated, and where Ukraine is the actual victim and not the Council of Europe member states. So I think we should definitely keep that in mind, and what you raise, and also what Christoph has referred to with regard to the support from the Global South. I think that's a very important contribution that the Council of Europe can make. And that should not be forgotten. Yes.
Thank you, Paula, for your comment. Ladies and gentlemen, our webinar comes to an end, and I would like to ask co-organizers to speak on behalf of institutions and make the summary. So maybe right now in reverse order. So we'll start with the RGSL. I see that Eva Racna is taking the floor.
Oh, well, thank you, Adam. I think it's the job has been done, and thank you all the speakers, and especially Christoph Stamos, because we are always feeling for Christoph, and also, of course, Professor Nussberger and Paula, you as well. And as always, I just can tell all the participants to follow us on the social media. We are preparing the next webinar as we speak. And see you next time. And thank you, Adam, for moderating. You are the best as always. Thank you.
Thank you. Professor Angelika Nussberger, floor is yours.
Well, thank you very much. I don't have much to say. I just want to thank Adam for his excellent idea of setting up these webinars, because we see that it's very helpful and very good to discuss before the event is happening. And we can bring together a lot of ideas, and we might reflect together how we might spread them even more, publishing some articles before in newspapers or in blogs or whatever, So in order to be active before Reykjavik happens, afterwards we can say what has not been accomplished, but before it's good to have a say. So a big thank you to Professor Sands, who is no longer here, but I think it was very impressive to hear him and to hear also and to see how close he is to all that is happening. Thank you.
Thank you very much, Professor Nussberger. See you in Cologne soon, hopefully. And ladies and gentlemen, it is my pleasure to close this webinar. I think we are really fortunate to have Professor Philip Sands with us. I think this is a great appreciation of our effort concerning the Reykjavik. And let's hope that conclusions of our seminar will be taken into account in the preparation for the Reykjavik summit. I know that among us as participants, but also as discussants were people who were preparing and lobbying strongly for proper inclusion of different set of values and human rights and rule of law into the final Reykjavik declaration. I have my private dream that maybe today Mr. Zełenski together with Mr. Duda will declare that they are going to Reykjavik together, because it seems to me that the presence of number of leaders depends to great extent, maybe not that much on the decision of Mr. Duda, but rather on the decision of Mr. Zełenski. So I think that if he decides to go, then the Reykjavik summit would be much more ambitious than we can, than it seems as of now. But it is our role as scholars and as lawyers to deliver different arguments, views, and ideas. And I think that such people like Ralph Lemkin, like Hersch Lauterpacht, and Philip Sands confirm that the role of individuals is extremely important in shaping the international legal order. Ladies and gentlemen, I would like also to thank Dr. Filip Cełuńczyk for his preparation and for all the work he's doing in the context of the preparation of those webinars. Philip, thank you very much. Ladies and gentlemen, our webinar is closed. Thank you.